Little bit of housekeeping. The 23 case shows as closed and consolidated into 23-458. However, there was a misunderstanding. All the counts of that case should have been consolidated into count 1 of case number 23-458. Is that correct, Mr. Sullivan?
Yes, that's correct. From a practical matter, yes.
I'll be honest with you, I think consolidating is something the state does. I'm not sure how the clerk, it's all dismissed for the clerk.
Yeah, and I would need this for JAC so that I could show that the case is closed.
Yes, ma'am. That's where it matters right there.
Yes, it does. Mr. Terry is scheduled for trial in case number 23-458, and I believe for evidentiary hearing in the remaining 2 case numbers. He has been given a plea offer of 25 years DOC, and it's my understanding that he does not want to take that. Is that correct, Mr. Terry?
Yes, ma'am, that's correct.
Mr. Terry also wishes to address the court. I believe he has mailed something to the court. I didn't see anything in the file. Don't know if that has made it here yet, but he has some issues that he would like to address.
Let's see if there's anything in the court file. I didn't see anything like that. Lawyer Hensler, state your name.
Sean Thomas Terry.
Mr. Terry, what would you like to address with the court this morning?
Well, some major conflicts of interest and irreconcilable differences between me and Miss Bennett have come about, and I filed it with the clerk of court. I also have copies of it here.
Just tell me, it's not in the clerk's office, so you can tell me what your issues are. It'd be the best thing to do.
Well, the first thing that, I have an issue with is Miss Bennett called me a snitch the first time she met me and developed a biased opinion against me, not even looking at my discovery to see any information that's in my discovery. And also, some other things have aroused to where a family member of mine has, was supposed to testify against her godson, and Miss Bennett has been made aware of this, and she even agreed that it's a conflict of interest in that matter. And, some other things besides that, Your Honor, but she also filed a motion on October 24th certifying a conflict for some of the same reasons. And the only reason why I didn't go through with this conflict is Miss Bennett, the day of, told me if I didn't go through with it, that she would file a motion to suppress and this be resolved. And then it took 5 months to get a simple suppression filed and heard to where I'm pushed all the way until trial. And I haven't even prepared any defense. I haven't had time to call any of my witness lists that I've given Miss Bennett or anything to this matter. And I just feel like I'm not being represented adequately at all. I feel like there's too much conflicts and irreconcilable differences that can't be repaired between me and her.
Not correct that I called Mr. Terry a snitch. What is correct is that I told him that I do not like to work with people who do snitch because that it creates conflicts. However, if the case warrants testimony against other people, we can set it up properly with the state and the state attorney so that there is actually a benefit, as opposed to defendants doing that behind my back, which oftentimes results into them giving information without receiving a benefit or creating a conflict. Furthermore, the testimony against what he called my godson, there was no conflict. I wasn't even aware that this was a family member until late last week. But I understand that Mr. Terry perceives it to be so. And other than that, I would say that Mr. Terry has misconstrued the situation altogether. However, I understand that that's what he feels, and I think in light of that, he probably would set this up for 3850 if we go forward.
I'm not as concerned about that. I mean, that's something that happens after a trial and after appeals have been. So that's, You filed a notice of appearance September 23rd,
Correct.
26th day of September, and according to Mr. Terry's own testimony, evidently he had an issue back then, but never, we're here at the morning of the trial. A motion to suppress was filed. A motion, a hearing was held. There's been an order. I'm satisfied with Ms. Bennett's explanation.
Furthermore, for the record, Mr. Terry has told me he believes I haven't properly relayed his counterplea offers to Mr. Sullivan, which was 10 years or less. I've told this to Mr. Sullivan, and they have declined that. Is that correct, Mr. Sullivan?
That is correct. And Mr. Terry, even as of last Friday, was trying to provide information on other cases for a better plea deal, and I've not been interested. Ms. Bennett has relayed that to me multiple times.
What's his overall exposure for what's going on, what we're going forward with this week?
He's charged with first-degree felony in the case that is set for trial. So his exposure on that one is 30 years and 5 years on each of the violation of probation. Mr. Sullivan has advised me, and I have told Mr. Terry that Mr. Sullivan, if this goes to trial, may add an additional first-degree felony, which then makes this a 70-year exposure.
Mr. Terry, I don't find that Ms. Bennett is, her representation is falling short of what it should be. She has filed the motion. She's, and you're prepared to go pick a jury today and go to trial this week?
Yes, sir.
The only thing that I'm asking, Your Honor, is for a continuance. My mother lives down south and she's looking to obtain me a lawyer.
That's
She
denied.
already,
We're sticking a jury this week. If you were going to hire an attorney, you've had sufficient time. You've been in custody. This is a 23 case.
yes, sir, but I haven't had any time to do anything in my case. I've seen Miss Bennett once in person in 20 months
That
that
is
I've been at the jail.
That is correct. However, my investigator went out to Mr. Terry multiple times, and I had video sessions with him also multiple times.
This was set for trial.
And I mean, the only thing is, I've never been to a trial management. It was set for trial. I went to a motion docket and then,
What would that matter if you were set for a trial management? You
Well,
were
no,
set for free trials, and they're basically the same thing. We just call it a trial management.
I understand that, Your Honor. And like I said, I mean, the only thing that's been spoke to me about trial has been in the past week. I mean, I have witnesses that I want to call forward in this case that I can't even call forward.
Has there been a witness list?
No, sir.
Have you
I gave actually her investigator, the only one who's seen me, I gave him a witness list about 16 months ago of people that was actually in the car with me and actual time and dates of where they could get this evidence footage from the bank surveillance camera, you know, to basically expose that there was other people in the vehicle with me, which would very much help my defense in this matter.
Ms. Bennett, do you have a witness list?
I remember that Mr. Terry had that, and I addressed it with him. And I asked if these people will come forward and admit that the drugs were theirs. And he said, no, they will not. And so with that in mind, I think it is actually going to be the exact opposite if people come forward and say the drugs are his. And therefore, I decided not to call them or investigate that any further. Furthermore, Mr. Terry wanted to list any character witnesses, and I told him that in this particular case, I wouldn't see any need for a character witness other than potentially for sentencing. And of course, he can invite anybody he would like for sentencing.
Mr. Terry, I'm going to deny your motion to appoint another attorney based on your testimony. Ms. Bennett's responses. I'm going to deny your motion for continuance. And we're ready to pick a jury today. And when we're going to try the case? Thursday.
That's correct.
Okay. And you understand that you're looking at a total of your maximum exposure of 70 years. Do you understand that?
I mean, I guess so, Your Honor. New charges haven't been filed against me. And my understanding is Friday, there was a forced supplemental discovery response from the state that I haven't even been able to look at or even know what that is. That's what I'm saying. There's a lot about this that I've never even been talked to about trial until this past week. And this is potentially a life sentence for me. I just don't understand how 1 month would render the court any inconvenience just to allow me to at least be able to obtain proper counsel, or at least get with Ms. Bennett and obtain a proper defense. She hasn't spoke with me about any defenses in my case, Your Honor.
I just wanted to address the supplemental discovery. Those were pictures we took of the fentanyl at BCSO. Ms. Bennett was with us. So just to avoid the high potency narcotics coming to court, that's what that supplemental discovery is. So it's nothing new.
And then there was another one that was shortly before that. That's for the defendant's statement. And Mr. Estes has been out at the jail to play those for him.
And the only thing that, you know, they said they're adding new charges. I haven't even got an FDLE report about these new charges or anything.
Well, we're just picking on it. What are we picking today? Trafficking? Trafficking?
But they're talking about adding new charges of trafficking something else that I've never even
We're not going
heard
to
of
trial
that
that this week, is that
existed.
correct? All right, well, you know, you understand what you're looking at, and we'll pick a jury sometime this morning. We'll try the case on Thursday. I'm going to deny both your motions.
And just to be clear on the trafficking and fentanyl and the two BOPs, he is an exposure of 40 years.
Okay.
Without any new charges.
You understand that, sir?
Yeah, is there any time that I can just at least think about this plea deal? I mean, just get a continuance for that to talk to my family about.
We're going to pick a jury this morning, sir. This is the time to make a decision one way or another. We have jurors come. I'm assuming we have jurors at the courthouse. We're picking a jury, or I'll accept a plea if there's I'll accept either an open plea or a negotiated plea before we pick a jury. But
I mean, is there any way that we could negotiate anything less?
I'm
than
not negotiating,
25
sir.
years?
No, sir.
I know
You
you're
can
not.
plead straight up to me to whatever.
Just for the record, count one has a minimum of 25 years. So that's where that 25 years is, and we're not going
So
below.
the state's offering the minimum mandatory.
Minimum mandatory of 25 years.
All right. You can have a seat and think about it right now while I take.
Yes, form if you want to read.
5-5222FY. Again, Mr. Gilly, you're appearing for arraignment purposes this afternoon, and you're appearing with Ms. Mistley, the defense attorney available through the Indigent Defense Council here to assist you. Ms. Mistley, did you have opportunity to review allegations on the complaint, nature of the offense, and the possible maximum penalties with Mr. Gilly?
I did, and we will waive a formal reading of that felony complaint, enter pleas of not guilty as to each count, and request the assignment of counsel.
Mr. Gilly, in order to complete a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Would you please raise your right hand? Thank you. And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yeah.
Thank you, and you're welcome to lower your hand. Mr. Gilly, do you have a telephone number?
Mm-hmm.
What is that?
989.
And what is your mailing address?
I don't really have one right now. It's just, you know, my last address on my driver's license. I don't know. I don't get mail there though.
Okay. Before you came to jail, where were you staying? Where were you living?
Did you just hear what I said to the magistrate and okay, or whatever, to the person I was talking to in private?
No, she did not. We were speaking privately, sir.
Was that recorded to share
No.
with our attorney?
Nobody heard that but you and me.
Okay, so I guess I have to repeat myself.
Well,
Anyway, is this being recorded now?
yes.
Okay, yeah. Anyway, I saw a black and white video on the internet about psychotropic drugs being
Mr. Gilly, just hold on. Please don't talk about that because it can be used against you. Just tell her your last known address, okay? Just tell her your last address that you remember.
Yeah, it's on my license, 135.
Do you receive any source of income or assistance?
Yeah,
What kind of income do you get?
SSA.
Do you own a vehicle?
Not anymore.
And do you have any money in a checking account or savings account? Any cash on hand?
Not to give you.
Well, this would be to see if you could hire your own attorney. Do you think you could qualify to hire your own attorney?
Possibly, maybe if I save up some money.
But not right now? You don't have enough right this minute?
No,
Okay. So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, it will be scheduled for August 12th. It would be at 11 a.m. with Judge Stefka. Also, on August 6th, you'll have a probable cause conference. So we also have with us this afternoon Ms. Muggenberg, the prosecuting attorney for Grand Traverse County. And Ms. Muggenberg, for the people, do you have information you'd like me to know regarding bond?
Yes, Your Honor. When you consider pretrial release, I've asked you to consider a number of factors, including prior criminal record. The defendant does have 2 prior assaultive convictions, as well as at least 1, if not more, malicious destruction of property convictions. Additionally, he does unfortunately have a history of mental illness, including prior involuntary hospitalizations. It also asks you to look at the seriousness of the offense. Clearly, this is one of the most serious crimes that someone can commit in the state of Michigan, and it has a huge impact on public safety. The probability of conviction is something else the court is told by statute to look at, and in this case, I can say as an officer of the court that the majority of this crime was caught on surveillance video. The defendant is not employed. Sorry? No.
I didn't say anything.
The defendant's not employed, currently homeless, and talking to his family, he has little to no contact with them, unable at this time to reside with family members. So we would ask the court to put in place a significant cash bond at this time. We believe that it's truly the only way to protect the public at this point.
Note that Mr. Gilly has no prior felony convictions. His last offense was over 11 years ago. He is, I did see in the praxis reference to 1 prior mental order entered by Presque County Probate Court. That was in 2022. I don't know if that's still in effect or not. My guess is it is not. That he likely did a deferral, and it's no longer under an order. But again, I don't have the lien, so I don't know that for sure. Sure, everyone else has it available other than the defense. So, contrary to the statement in the praxis, 6.106, the court's not required to essentially give a 10% or cash surety bond. I believe that it is required for the court to set a bond. Subparagraphs 1A and 1B do not apply here, as we don't have a defendant charged with treason, murder, or violent felony, and at the time, he was not on probation, parole, or release for another violent felony, nor is this a CSC or not robbery or kidnapping. So we would ask the court to set an appropriate cash or surety bond. Thank you.
So the court is very concerned about the allegations in this complaint. Certainly is one of the most heinous accusations from an individual that's been before this court in 30-some years.
Well, you know the Tibet, y'all, like, have the tobacco company and you're selling cigarettes with fiberglass and chemicals in them just to kill off this population, and you can't really accuse me of anything if you're doing that, so.
Okay. So I'm going to mute you for right now because I need to let you know what my decision is with regard to bond. Mr. Gilly, your bond is going to be a $100,000 cash or surety bond. Conditions on the bond are that you may not use nor possess any alcohol, any illegal substance, or any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You would submit to 4 times per month urine screens. You would submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You may not use nor possess any weapons of any sort, nor use any object as a weapon. You will have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. You may not return to any Walmart. You should hear from your court-appointed attorney by the 1st of next week. And once again, your preliminary examination will be August 12th. Ms. Mistley, do you have anything further?
I do not. Thank you.
And Ms. Muggenberg?
Nothing further. Thank you.
Thank you. So for right now, Mr. Gilly, you are all set. We will see you on August 12th. Thank you.